Good morning. My name is Larry Green, and some of you know me out there, and you've probably seen me around here for about 27 years now. Anyway, I'm a supervisory attorney in the Office of Federal Operations. As I said, been here for a long time. I've been asked to talk to you guys this morning about the mixed case process. I know some of you have heard a lot of things about the mixed case process. It's boring, it's complicated, it's scary. Not at all. It's no big deal at all. Everything you need to know about the mixed case process can be found at 29 CFR 1614 302 to 309. That's 1614 302 to 309. Right there. Easy peasy. First question. What are mixed cases? A mixed case occurs when you have a statutory right to challenge an agency action in two forms which overlap jurisdiction: the Equal Opportunity Commission and the Merit Systems Protection Board, the MSPB. If an agency takes an adverse action that can be appealed to the MSPB, and the employee also alleges that the action was motivated by an improper discrimination or reprisal for protected EEO activity, then you have a mixed case. Next slide. Definitions. Now this one's pretty easy. It's a statutory, it's right out of the statute. What is the MSPB? As you can see, the Merit Systems Protection Board is an independent quasi-judicial agency established in 1979 to protect federal merit systems against partisan, political, and other prohibited personnel practices, and to ensure adequate protection for federal employees against abuses by agency management. As I said, that's the textbook definition. Let's go to the next slide. Now, there are certain actions that can be appealed to the MSPB, and here are some of the more common ones: reductions in grade or removal for unacceptable performance, suspensions for more than 14 days, or furlough for 30 days or less. I think we all know about those furloughs, right? For cause that will promote the efficiency of the service, and separation, reduction in grade, or furlough for more than 30 days when the action is due to a reduction in force. There's a site here that you can go to for a more comprehensive list of the different actions that can be appealed to the MSPB. More than we have time to talk about here today. But like I said, you can go to that website and get all the information that you need. Now let's go to the next slide. Not every action that can be brought to the MSPB is a mixed case. I want to make that clear. There's some things you can go to the MSPB about that don't involve allegations of discrimination that are covered by the EEOC. So let's look at some of these. Allegations of discrimination based on partisan political reasons. Appeals under the Uniformed Services Employee and Reemployment Rights Act, or the Veterans Equal Employment Opportunities Act, and the Whistleblower Protection Act. None of these causes of action can be appealed to the EEOC, so they're not mixed cases. Now here's an example. An employee is suspended for 30 days. He alleges that his suspension was in violation of his due process rights, his civil service procedures, or for partisan political reasons. Although the MSPB will most likely assume jurisdiction over that case, this will not be a mixed case because there was no discrimination statutes involved in this person's allegations. But if he alleges that in addition to the above, his suspension was also due to his race or his age or his sex or color, religion, genetics, then that would make it a mixed case. And he can file with the EEOC or the MSPB, but not both. Now, there are two types of mixed cases. There's the mixed case complaint, and there's the mixed case appeal. And they both have different procedures and both require different things, if you will. Now let's start with the mixed case complaint. Excuse me. hot up here in all these lights. A mixed case complaint is a complaint of employment discrimination filed with a federal agency based on race, color, religion, sex, national origin, age, disability, or reprisal related to or stemming from an action that may be appealed to the MSPB. The complaint may contain only an allegation of discrimination, or it may contain additional non-discriminatory claims that only the MSPB has jurisdiction to address. There's no right to a hearing before an EEOC administrative judge when you file a mixed case complaint with an agency.
Larry, let me ask you a question about the jurisdictional, the width of the jurisdiction of the MSPB. I know from my own personal experience that you're not going to be able to memorize those things, but there are really two parts to it, right? There's the standing issue, and then there's the issues that they cover. Is the standing come into this, or is it just the kinds of claims? You understand what I mean?
We don't. Standing is not really a factor here. I mean, in our situation, because I mean, obviously there are some. That would be more of an issue if it's a mixed case appeal when you file directly with the MSPB. If you're filing a mixed case complaint with the agency, we usually don't get into those types of issues, like whether or not a person is a probationary employee or a full-time employee. Those kind of issues don't come up in the mixed case complaint area, which is mostly what we're going to be dealing with when we get something at the commission.
But we only care about that if it's an appeal, and then we have to decide whether we're going to hold it in abeyance or something like that.
Well, I'll talk about that a little bit later, but what you'll see is, let's say a person files a mixed case appeal with the MSPB directly from their agency, and they don't meet the certain criteria that the MSPB has. Well, that's a procedural decision that the MSPB has the right to make the call on. For example, what I was saying, if a person's a probationary employee, they may not be able to file an appeal with the MSPB. That's nothing that we have any control over. So if the person were to file something with us saying that they were dismissed by the MSPB, their appeal, there's really nothing that we could do in that situation, because the MSPB sets the criteria for what cases they're going to accept, whether the person has standing or not. Now, if the person filed a mixed case complaint with the agency, that would be that's a different scenario, if you will. Now, they have to meet certain criteria. I mean, in that situation, a probationary employee can file a complaint of alleging discrimination, whereas they may not be able to file an appeal with the MSPB.
I see. Okay. Thanks.
Right. So, mixed case complaint. Oh, I think I did that already, didn't I? Mixed case appeal, as we were just talking about just a second ago. A mixed case appeal is an appeal filed directly with the MSPB that alleges that an appealable action was based in whole or in part on discrimination because of race, color, religion, sex, national origin, disability, or reprisal. Now, next slide here, goes back to talking about mixed case complaints. This is the procedure for how that happens. The employee files a mixed case complaint with the agency. The agency must process the complaint in the same manner as it would any other discrimination complaint, except although the agency has 180 days to investigate the complaint, as you can see here, if no FAD has been issued, if no final decision has been issued within 120 days, the employee can go directly to the MSPB. And that's the section in our MD that talks about that. MD 110, Chapter 4. Now, the final decision must address the merits of the complaint, but is appealable to the MSPB, not the EEOC. Let me stress that. In a mixed case complaint, when the FAD is issued by the agency, the employee has the right to file an appeal to the MSPB, not to the EEOC. The MSPB then will assign an administrative judge who will conduct the hearing and issue a decision. The decision of the MSPB will address the alleged claim of discrimination and any other non-discriminatory claims. If you remember what I was saying, has like things under the Whistleblower Protection Act or the Veterans Protection Laws. That decision will address all of that. But only the discrimination complaint, that area can be appealed to the EEOC. Under a mixed case appeal, with the mixed case appeal, the employee files the appeal directly to the MSPB itself, and the MSPB will assign an administrative judge, the same as with the mixed case complaint. A hearing will be conducted and a decision issued that will address both the claim of discrimination and any non-discriminatory claims, discrimination claims. So let me go back. In a mixed case complaint, you start at the agency, you file your complaint, the agency investigates, issues the final decision with appeal rights to the MSPB, not to the commission. Under a mixed case appeal, you file directly with the MSPB. They assign an administrative judge who holds a hearing, issues a decision, and that decision is appealable to the commission, but only in the area of discrimination. All the other non-discriminatory statutes or rights are not appealable to they can't be addressed by the commission. Now, with both the mixed case complaint and the mixed case appeal, the employee can file an appeal of any adverse initial decisions to the full board. If you think about it, you're first in front of an administrative judge who holds a hearing and issues a decision. If you don't like that decision, you can file an appeal to the full board, and that's to the MSPB commissioners. Just like us, they don't have a full quorum right now, so that aspect is not available to their employees.
So Larry, just let me ask you a question about that, because this has come up in training not very often. But because they don't have a quorum, can people then appeal to EEOC from the decision directly from an administrative judge decision? Yes. Okay.
And those are the decisions that we're getting right now. I mean, it's the employee right now has the option of waiting until such time as there's a quorum, or after this, it's usually like 30 days after the administrative judges issue their decisions that they become final, and then within 30 days of that, then they can file an appeal directly to us.
So it's probably an advantage for them in any case. This probably works in somebody's favor if they want to appeal. They'd rather have EEOC look at it than the full board, probably.
Yeah, I mean, that's a strategic decision that each employee is going to have to make. But it sort of gives you an extra bite at the apple. I mean, let's say that the MSPB had their full complement of commissioners, then why not take the opportunity? I mean, you could go to them and then they issue a decision. I mean, you're in no worse shape because the same rules would apply, because after the full board issues their decision, then that's the final decision of the MSPB. So then 30 days after that, it becomes final, and then you can file an appeal to us.
So without the full quorum, the AJ's decision for the MSPB is considered a final decision?
Right. And like I said, there's usually like a 30-day gap between the decision and it becoming final. But yes, that becomes the final decision of the agents of the MSPB.
Okay, thanks.
And getting back to the review of the full board, that review is discretionary. The board does not have to grant the board doesn't have to grant a review, but they can if in their discretion they decide to. The board can either reverse the initial decision and find discrimination or some civil service violation, or they could remand the case back to the administrative judge for further review, development of the record. In the event that the final decision of the MSPB results in a finding of no discrimination, an employee can petition the EEOC to review that determination. The Commission's review is limited to the discrimination claim only, as I said before. The EEOC will determine whether the MSPB correctly interpreted our regulations, our statutes, or our guidance. If the final decision addresses a procedural matter, we have no jurisdiction over that. Excuse me. For example, if the MSPB dismissed the employee's appeal because it was untimely, or if they find that they lack jurisdiction over it, and that was like a question that we got earlier. Sometimes the MSPB dismisses a case because they simply don't have jurisdiction over it, and in that case, such as standing or different things like that, those are issues that we have no control over, no jurisdiction over, no power to review. Also, if one of our statutes are not implicated, if the MSPB issues a decision that addresses the Whistleblower Protection Act, we have no control over that, and therefore they're wasting their time filing an appeal with us on that because we're going to deny consideration of that. The next slide. In the majority of cases, we concur with the MSPB's final decision. It's simply, just like in the majority of our cases, we find no discrimination. However, there have been cases where we have differed from the board. It's rare, but it does happen. We find that, they find no discrimination, and we simply disagree with them. The MSPB then must decide whether to accept our decision. If they accept it, then they'll go ahead and issue a remedy. If they don't accept it, if they reject our decision, then we have to go to what's called a special panel to basically break the tie. And these are very extremely rare, but they have happened. And I'm aware of at least 2 or 3 that have occurred in the recent years. Let's go to the next slide, the most common questions. The following are questions and concerns that often arise in the mixed case processing area. First is called dual filing. As I said earlier, an individual cannot file a mixed case complaint and a mixed case appeal on the same matter. Our regulations provide the first thing that's filed controls. And a mixed case complaint filed after an appeal would be dismissed by the agency pursuant to 29 CFR 1614-107 subsection 4. If the mixed case complaint is filed first, then the agency should notify the MSPB so that they can dismiss the appeal.
Larry, I've seen circumstances, or had them brought to my attention, where an appeal was brought to the MSPB first, and it was brought to their attention. Second, it should be dismissed by the MSPB, and they don't, for whatever reason. How do we treat that? We just let them continue on with the jurisdiction, or we say, no, this is ours? A couple times people have come to me with those personal cases. I couldn't check into them, but just where MSP doesn't dismiss something when it was filed with the agency first.
Well, I guess you would have to look at where we are, where it is in the process. And if I'm incorrect in how I'm interpreting this, there's an adverse action, the employee files the MSPB, then he turns around and files a complaint with the agency.
Well, in that case, the agency would dismiss it.
The agency would dismiss it.
I'm saying, in this case, what you're saying here, the MSPB should, if the mixed case complaint is filed first, the agency should notify the MSPB, and then they're supposed to dismiss it, right?
That's correct.
Right. So, but if they don't, what would be the agency's action?
Well, they've contacted the agency doesn't dismiss. We have a complaint that's going on. So the mixed case complaint controls. Well, okay, so I guess in what should happen, or I mean, obviously we know what should happen.
Right.
The MSPB should dismiss it. But ultimately, if the agency goes ahead and proceeds, issues a FAD with appeal rights to the MSPB, then it seems to me that we end up in the same place that we would have been in anyway, because ultimately everything's going to be in front of the MSPB.
So the only time it wouldn't is if the agency decided there was discrimination.
Well, remember now, in a mixed case complaint, okay, well, you're right. I mean, if the agency admits that they discriminated against the person, then
I didn't mean to screw you up here.
that's okay. I love these hypotheticals, you know. But yeah, I think that the main answer though to your question is that in that scenario, I can't imagine why the MSPB would want to proceed in something that they don't want, that they don't have to. I mean, that would be the first thing. I mean, you're the agency and you're notifying them that, hey, this guy's already filed a complaint on this issue. You guys don't have to proceed. It's sort of, you know, it's kind of impossible for me to see why they would continue processing.
I'm guessing that those questions came to me from agency people, and it was just a matter of timing.
Yeah.
MSPB hadn't done it yet.
They hadn't done it yet. But yeah, but the bottom line is that I think that the agency should continue doing what they're doing, you know, what they're required to do, issue their final decision with appeal rights to the MSPB, and then ultimately everything's going to get married up at the time anyway. And like I said, like you said, it's probably just a matter of timing.
Mm-hmm. All right.
Okay, the next area would be lack of jurisdiction. Excuse me. When the MSPB dismisses an appeal for lack of jurisdiction, the employee still has a discrimination claim that needs to be assessed. If it's a mixed case complaint, the agency must notify the employee that they have the right to an EEOC hearing or a final decision. If it's a mixed case appeal, they should be notified of their right to EEO counseling. Because the employee filed directly with the MSPB, in that scenario, there's never been EEO counseling. The date of the appeal was filed with the MSPB is deemed the date of EEO counselor contact. I can't stress to you enough, agencies often fail to do this, to notify the employee of what their rights are. And so we end up with a number of appeals to us where an employee doesn't know what they're supposed to do, so they end up filing something with us after the MSPB has denied jurisdiction in their case. And you can't blame them because, I mean, they don't know what their rights are. So they're out there wandering around with what they consider to be a viable claim, but nowhere to go because the MSPB has denied jurisdiction and the agency hasn't notified them of what their further rights are. If agencies would do that, then that would cut down on a number of meritless appeals that we end up getting.
So, Larry, what is the issue there? Is it that the EEO offices that would be contacting them to talk about the right to counseling don't know it, or is the issue from MSPB? What is it? Just that those things slip through the cracks? Why is it that agencies don't do that?
You know, you're probably right about slip through the cracks. I mean, because it's probably one branch of the agency that's handling the person's appeal. So maybe you have a lawyer from GC who's filed a motion with the MSPB saying, hey, you guys should dismiss this claim because there's no jurisdiction. That's done. And so the lawyer from GC has done his job, he's won his motion, but no information then is transmitted. I mean, the MSPB doesn't have that obligation. The regs say the agency does. So somehow the GC attorney needs to communicate to the EEO office that this has happened.
So they may not even be aware of what's going on.
They may not even be aware of it. So, you know, months go by and the employee is sitting there with a viable claim, and he doesn't know what to do. So then, no one's gotten in touch with him to explain what his further rights are. So then somehow he finds out that the EEOC is the place that you're supposed to go with this. So he files an appeal with us, and there's nothing for us to look at because we can't tell the MSPB that they do have jurisdiction. The only thing we can do is order the agency to do what they were supposed to do originally, which
Right.
is notify the employee of what their rights are.
So let me push you just a little bit harder on this. If we're teaching counselors, we're talking to counselors and that this is an issue and they recognize this is an issue because maybe they have other duties as well and an e-office is often common. What do you see as a solution for this? How can we as EEOC help agencies get over this issue?
There has to be communication between the, well, I don't want to get into firewalls and things like that, but obviously there has to be some way in which the information about what happened with this case gets back to the agency, to the parts of the agency that are supposed to notify the employee, which is the EEO office. Somehow that information needs to be communicated to them. Essentially, if you look at it, if let's say it's a mixed case appeal, the litigation has stopped when the MSPB has decided that they don't have jurisdiction over the case. Pretty much everything has stopped at that point. So maybe at that point, maybe somebody from the lawyers ought to let the EEO folks know what happened and let them do what they're supposed to do now, would notify the employee. Same thing with the mixed case complaint. Somehow that information needs to be to get back to.
That's just better agency communication. However, we can
make
agencies see those things.
Because like I said, the only thing that we're going to do is deny the petition from the employee because we're not going to consider it. Nothing for us to consider. No, in that scenario, no decision has been made on the merits. So there was no determination by the MSPB on the discrimination claim. They just dismissed for lack of jurisdiction.
Do we allow people to go back through the process at the point that we dismiss their claim for, because
well,
we have
remember
nothing to
now.
decide?
Remember now what's going on. A decision has been issued by the MSPB. It's nothing that we, the EEOC, has. We're at this point we are not involved in this case in any way.
No, I guess what I mean is that if they the first they find out that they should have come back and had counseling and everything else is because they file appeal to us and we say, sorry, we have nothing to do with this.
Yes, the regulation says if it's a mixed case appeal, the agency, whether they do it because they did it themselves or whether we told them to do it, under the regulation, the agency notifies the employee that they have the right to go to an EEO counselor within 30 days. And the date that they first went to the MSPB is considered to be the date of initial EEO counselor contact. Because that's important because, as you know, you have a certain number of days to go to an EEO counselor after you discovered that you've been discriminated against. So in essence, if you chose to go to the MSPB first, we're going to treat that date as the date of initial EEO counselor contact. Now, if it's a mixed case complaint, it's a little bit different because if you remember in a mixed case complaint, you've already gone to an EEO counselor, there's already been an agency investigation, and there's already been a FAD issued with rights to go to the MSPB. So in that scenario, they put you back in the spot that you were. So now you have, instead of going to an EEO counselor in a mixed case complaint that has been dismissed for lack of jurisdiction, you have the right to either have a hearing in front of one of our AJs or an immediate final decision. And in that decision, we give you the right to come to the commission on appeal.
Are they informed of that more often than what we were just talking about in the former case?
Well, we only know what we know. I mean, if the agency is doing what they're supposed to do, at least
should be following what's going on, so they're much more likely to be able to know because it was before them at one point.
Yeah,
Yeah.
And like I said, if the agency is doing what they're supposed to do, we're not seeing those appeals. What we would see is the finished product. The person who's gone through EEO counseling now, and he's filed, he gets a final decision or an AJ hearing, and then we're dealing with that. We're not really dealing with something direct coming from us from the MSPB.
Okay, I'll let you move on.
Okay, the third area are mixed and non-mixed claims. Suppose an agency has an employee who has filed a mixed case complaint containing related non-mixed claims and mixed claims. In the past, the EEOC would encourage the MSPB to take jurisdiction over the entire case, or to, on the basis that the claims were inextricably intertwined. That's some of you people who have been following the commission for a long time are familiar with that term, inextricably intertwined. Based on our discussions with the MSPB, however, over the years, our position on that has changed, and we now instruct agencies to pretty much bifurcate the complaint, to process the non-mixed claims while the MSPB deals with the mixed claims. And let me give you an example. As you can see right here, an employee he's alleging that there was a discriminatory performance evaluation. He was subsequently placed on a PIP, and subsequently that resulted in a removal. Now, only the removal is appealable to the MSPB. The PIP and the evaluation are not. The MSPB will generally not assume jurisdiction over non-appealable matters, even if they're related. I mean, as you can see, it clearly these three claims are all related. I mean, he was, like I said, he was given a bad evaluation, he was placed on a PIP, and subsequently removed because his performance didn't improve. Logically, these things are all related, but two of them are not appealable to the MSPB. Only one, the removal, is. So in those situations, in the past, we would argue that they were inextricably intertwined, and therefore all three should remain together and all three should go to the MSPB. Today, that's not our current approach. The agency should process the performance evaluation in the PIP, while, as I said before, the MSPB deals with the removal. And this would mean notifying the employees of their rights in a FAD that basically is sort of bifurcated. In one sense, you go to the MSPB on the removal, and you have the right to an EEOC administrative hearing on the PIP and on the evaluation. And as you can see right here, there's a site for one of our decisions that talks about this doctrine, or the end of the inextricably intertwined doctrine, if you will. Number 4, investigations. Agencies have 180 days to investigate non-mixed claims. If the investigation of the non-mixed claim exceeds 180 days, the complainant may proceed to request a hearing before an EEOC administrative judge or to file a civil action in U.S. District Court. The agency also risks sanctions from the EEOC if they don't comply with the investigation during that period, that limited period of time. But what if we're talking about a mixed case? Doesn't the regulation pertaining to mixed cases state that the investigation has to be completed in 120 days? Actually, it doesn't. And a lot of people make that mistake of thinking that you have to get it done within 120 days, when really the regulation doesn't say that. What the regulation does say, however, is that if the investigation is not complete within 120 days, the employee has the right to basically bail on the agency investigative process and go directly to the MSPB. I mean, basically, this gives him, this is a right that the employee has. They can either sit tight and wait for the agency investigation to be completed, or they can go directly to the MSPB after the expiration of 120 days. So you have a question down there.
So this is similar to when someone doesn't have their investigation done within 180 days and they ask for a hearing.
Exactly.
It's just
Exactly.
the MSPB equivalent of that.
It's the equivalent of that. But somehow over the years, it's sort of gotten a little convoluted there, where people sort of have jumped to the conclusion that that means that the investigation itself has to be done within 120 days. And the regs don't say that.
Okay, thanks.
And that brings me to the doctrine of firmly enmeshed. Now, remember when we talked about the inextricably intertwined approach, which has been abandoned, basically that was a way in which an agency could try to compress all the claims in a complaint, the non-appealable matters with the appealable matters, and send it all to the MSPB. Firmly enmeshed is a different sort of scenario, different doctrine. Basically what that does is it means that the EEOC will assume jurisdiction over a claim that normally would have gone to the MSPB and should have gone to the MSPB. If we go back to the scenario that I had brought up earlier, where the person was a bad evaluation, they were placed on a PIP, and that resulted in their removal. What if the removal was not, the employee was not given appeal rights for the removal to the MSPB? All three of those were kept together. Should have gone to the MSPB on the removal, but it didn't happen. So it was processed. It went to an administrative judge. Judge issues a decision finding no discrimination. Person files an appeal to the commission. So now we're looking at 2-3 years down the road from when all these events occurred. The firmly enmeshed doctrine would basically state that because of the passage of time, because of procedural complications, if you tried to remand this back, these claims have become the appealable claims have now become so firmly enmeshed in the EEO process that we're going to keep them all together. So like I said, normally the removal should have gone, but it didn't. Now there's been that passage of time, events have occurred where it's just not practical to take this removal and send it back. So now we're going to leave it in the EEO process and it'll be addressed. Now that could happen in front of the administrative judge. You know, an agency might file a motion with the judge saying, Judge, this claim should not be before you. You have no jurisdiction over the removal. It should have gone to the MSPB years ago. Judge can say, no, it's firmly enmeshed. Let's say that didn't happen. It comes to the commission. Now it's in front of us. Agency files a motion saying you should sever this removal from the other claims because it should have gone to the MSPB. Firmly enmeshed says, no, we don't have to. It's firmly enmeshed in the EEO process. We're going to keep it there. We're going to address it. We're going to deal with it. And like I said, ideally, it should have gone to the MSPB, but it didn't.
So, Larry, what do you do? I mean, does someone have any kind of recourse? Can they appeal to MSPB to say, hey, this should be before you, or is this just whatever we say on this?
Well, again, I mean, the MSPB is not going to reach over and take something from the commission. It would have to be a situation where the commission says this claim should not be before us. We're going to remand it back to the agency and then have the agency send it over to the...
So you could have an AJ saying this is firmly enmeshed, and then on appeal to the commission, we say, or OFO, or whatever, it's saying, well, not really. This should go to MSPB.
I mean, theoretically, you could say that, but I think, you know, if you look at these cases, there are some cases that are cited in this slide Kohlers versus DOD, Richardson versus VA, where we kind of talk about these things. And there's another case too, I think is in here, Blunt, where we talk about these things, what the criteria is. I think that if an administrative judge finds that it's not firmly enmeshed, let's say, and therefore he orders the agency to send that back to the MSPB.
Mm-hmm.
You know, I think it will just have to be looked at in that individual case, whether or not there was abuse of discretion, that sort of thing. You know, the same thing that we look at when we look at any decision by an administrative judge. But I think that the bottom line, though, is that when you look at the reasons why an allegation is firmly enmeshed, it becomes firmly enmeshed. You know, it doesn't start off firmly enmeshed. Firmly enmeshed is not a way of getting around the inextricably intertwined doctrine. The rule is still that appealable matters should go to the MSPB, non-appealable matters should stay in the EEO process. However, sometimes, for whatever reason, things weren't processed the way they should have been processed, and it just simply makes no sense to years later send something back to the agency for them to send it to the MSPB when we can address it right here, and can and should address it right here.
So to summarize that, it's inextricably intertwined, which I'm going to miss being able to say that a whole lot, but inextricably intertwined really is something that starts from the beginning. It's a matter of what happened, the facts of a case, how they come together and how they work together, versus firmly enmeshed, which is just that because of a mistake or the passage of time, that the factors have been adjudicated together or the issues have been adjudicated together, so now it doesn't make sense to pull them apart.
Yes, I would agree with that. The only thing I would say, though, is that inextricably intertwined is no longer a valid approach. When it was a valid approach, that is true. I mean, two issues are logically related, and therefore the goal was to try to keep them together and to send them to the MSPB together. But in recognition of the fact that the MSPB is not going to take something that it doesn't have jurisdiction over, a non-appealable matter, the approach now is to bifurcate, keep the non-appealable matter there at the agency, or to, which will ultimately come to the commission, and send the appealable matter to the MSPB. And that's the mixed case process. If there are any other questions?
Believe me, if I could think of any, I would ask. But thanks, Larry. I really appreciate going through all of this. And for all of you who are listening to this, if you do have specific questions about mixed case, I think Larry would be amenable to answering any of them. If you run into any questions out in the training that you can't answer, or that scenarios that are difficult, he already said he likes looking through those scenarios. So I would encourage you to send him an email if you have an issue. But thank you, Larry. Appreciate your time.
And if you look at the last slide here, my email address is right there. And you can just write me right there at lawrence.green@eeoc.gov.
Great. Thanks so much.
You're welcome.